The India Bloc opposition parties demanded that Section 44(3) of the Digital Personal Data Protection Act be scrapped. They argue that the section completely undermines the protections of the Right to Information Act. Congress leader Gaurav Gogoi mentioned that more than 120 MPs from the India Bloc parties, including the leader of opposition Rahul Gandhi, have all signed a joint memorandum calling for the repeal. Now, this memorandum will be handed over to the Information and Technology Minister. At the press conference, several prominent figures were present, including M.M. Abdullah from the DMK, Priyanka Chaturvedi from the Shiv Sena UBT, John Brittas from CPIM, Javed Ali Khan from Samajwadi Party, and Naval Kishore from the RJD. Gaurav Gogoi noted that civil rights activists have been opposing Section 44(3) because it tries to replace Section 81J of the RTI Act of 2005. Under the old rule, remember, Section 81J allowed government bodies to withhold personal information only when its release had no connection to public activities or interests, or if disclosing it would invade someone's privacy unnecessarily. However, there was an important safeguard. If a central public information officer, a state public information officer, or an appellate authority determined that sharing the information was in public interest, then it could still be released. Now, the new section, that is 44(3) of this Act, changes this by letting the government bodies withhold any information which relates to personal information without considering whether disclosing it might serve a greater public interest or if any exceptions apply.
अभी जो डिजिटल डेटा प्रोटेक्शन एक्ट पास हुआ उसमें एक बहुत ही खतरनाक सेक्शन है, सेक्शन 44(3), which is amending section 81J of the RTI Act, and now it says nothing, notwithstanding anything contained in this act, there shall be no obligation to any citizen information which relates to personal information. And mischievously, the right of citizens to information has been snatched by the recent Digital Data Protection Act. We urge you to repeal section 44(3) of the Digital Personal Data Protection Act. और ये जो petition है, इस petition पर किन महान हस्तियों का, नेताओं का हस्ताक्षर और समर्थन है? आदरणीय राहुल गांधी जी का, अखिलेश यादव जी का, बालू जी का, जॉन ब्रिटस जी का, विभिन्न हमारे जो समर्थक करने वाले जो दल हैं, हमने विचार विमर्श कर हमने सोचा एक जल्द से जल्द एंड इमीडिएट एंड अर्जेंट एक्शन मस्ट बी टेकन.
डेटा प्रोटेक्शन बोर्ड जो बनेगा वो सेंट्रलाइज्ड इन नेचर होगा, यानी डिसेंट्रलाइज्ड भी नहीं है. जैसे अगर तमिलनाडु में तमिल बोला जाता है, वहाँ की पॉपुलेशन अलग है, तो उनको भी उसी के कमांड में ले आया जाएगा, सेंटर की कमांड में. महाराष्ट्र में मराठी बोलने वाले हैं, मराठी पर्सनल डेटा है, उसको भी सेंटर के कमांड में ला रहे हैं. कौन चेयरमैन बनेगा, कौन बोर्ड मेंबर्स होंगे, क्या उनकी सैलरीज होंगी, क्या उनके अलाउंसेस होंगे, क्या उन पे एक्शन लिया जाएगा, वो भी केंद्र सरकार के ही नुमाइंदे डिसाइड करेंगे. तो ये किस तरीके से फ्री एंड फेयर है. और साथ ही साथ सेंट्रल गवर्नमेंट के हाथ में ये भी पावर है कि वो डिसाइड करेंगे कौन इंफॉर्मेशन शेयर कर सकता है. प्राइवेट एंटिटीज भी, अगर हम प्राइवेट एंटिटी से भी इंफॉर्मेशन मांगेंगे, वो भी उनको एग्जेम्प्ट कर सकते हैं फ्रॉम शेयरिंग इंफॉर्मेशन. हम लगातार देख रहे हैं कि आरटीआई का पीएम केयर्स को आरटीआई से हटा दिया. कोई भी चीज जहाँ पे अकाउंटेबिलिटी सरकार की होती है, आरटीआई से हटा देते हैं.
This RTA Act was a milestone in the trajectory of the nation to be a modern democracy. Many of the enactments, laws passed during the UPA regime, like employment guarantee, like information guarantee, all these are being watered down by the present government. Now, all the opposition parties, which are part of the India Alliance, have come together to protest. And this is not solely an issue of the opposition parties. This affects the democratic process of this country. These are far-reaching implications on the freedom of media. These are far-reaching implications on the democratic process of this country, the transparency to the administration, and I would request you all to have a considerate look.
In response, the Minister of Information and Broadcasting, Ashwini, Vaishnaw, explained that the Digital Personal Data Protection Act of 2023 aligns with the transparency principles outlined in the Right to Information Act. He added that the Act also respects the privacy principles established in the landmark Puttaswamy judgment. In that judgment, the Supreme Court of India confirmed that the right to privacy is a fundamental part of the right to life under Article 21 of the Constitution, linking it directly to the protection of personal information. Now, throughout a wide consultation with the civil society and in several parliamentary discussions, experts and lawmakers stressed on the importance of keeping the provisions for the right to information and the right to privacy in harmony.